Welcome to our third contentious clinic and our first one of 2025. So thanks everybody for joining. This is our third in the series of our death to distribution sessions that are on the IDRN. The second one we ran was Early Days of a Claim, and you can actually access that via the IDRN, and I will add a link to the IDRN, our referral and support space for contentious and non-contentious probate. So I will add a link to that, and please do register for free if you're not already on there. This session is being recorded and will also be added to the IDRN following this, so you can share with colleagues and people who couldn't make it today. So yeah, as I said, this is the third one in the session, and it's issues arising after the grant. Today we are joined by two members of the IDR law team. It's Catherine Owsey, who is an associate solicitor, and Elspeth Gray, who is a solicitor from IDR Law, both quite new to IDR. I think they joined within the past year, so this is their very first clinic. So please be kind. If you have any questions at all, then you can add them to the chat and we can try and answer them at the end if we're within time. Or you can, I'm sure they will share their email addresses with you after, and you can send across an email to them. Just a quick one also before I pass over to Catherine and Elspeth. We do provide CPD certificates for the sessions, so if you would like one, I'll add the details in the chat and just take that away. Okay, and just another reminder, if everybody could just go on mute and hide the cameras because we are getting a bit of a feedback. But thank you. I'll hand over and please enjoy.
Hi, so I'm Catherine, and welcome to everyone joining us today for this month's contentious clinic. Thanks for the introduction, Lindsay. So I'm an associate solicitor, and I'm delighted to be joined by my colleague Elspeth Gray for what's the third session, as explained by Lindsay, in our Death to Distribution series. So the first two clinics of the series were presented by Eleanor and Kate and covered the issues which might arise immediately after death and those prior to the grant being taken out. So following on from that, today we're going to deal with the next stage and focus on the issues arising after the grant of probate has been issued. What are we going to cover? So the executor's year, the relevance of that and the steps which can be taken to protect an estate, the types of issues arising when executors fail to comply with their responsibilities and duties, and an overview of the pre-action protocol and the ACTAPS code. Before discussing each in detail, I thought it'd be useful just to have a quick explanation of what the term executor means and the explanation of the duties of an executor. So, as you will know, an executor is a term for a person appointed within the deceased's will to administer an estate. This can be a sole executor or there can be multiple executors. Numbers limited to 4, and it's usual to have 2 executors. The executors are the one to apply for a grant of probate. Where there's no will, the rules of intestacy will apply, and a grant of letters of administration would be issued by the probate registry. So, and in those cases, the person is the administrator of the estate. Administrator has the same duties as an executor. The key difference is their appointment. An administrator derives their authority from the law, and the executor derives their authority from the will. The collective term is personal representative, basically the people legally responsible for the money, property and assets of the deceased, basically their estate. In the clinic, we're going to use the term executor, just so that we're not interchanging through the different words and terms. So the duties set out for an executor are set out in section 25 of the Administrations of the Estate Act. This is detailed on the slide, and I'm not going to read this out because I'm sure you'll be very familiar with this. But practically speaking, what does this mean? So it's the responsibility of the executor to carry out the terms of the will as per the deceased wishes. And these seem straightforward enough. They realise the value of the deceased estate, they settle any liabilities or debts, and then distribute the estate in accordance with the terms of the deceased will. As we've said, where there's no will, the administrator has the same duties and distributes the estate in accordance with the rules of intestacy. It is advisable for executors to be meticulous in keeping records and to communicate with the beneficiaries. An executor's primary responsibility is to the beneficiaries, and that has to be kept in mind at all times. To discuss the issues arising when executors fail to comply with these duties, I'm going to hand over to Elspeth for her to discuss the executor's year.
Thanks, Catherine. So, as Catherine has just outlined, there are various duties and responsibilities that the executors must carry out. However, their duties to distribute the estate in accordance with either the deceased's will or rules of intestacy do not need to be completed within the first year of the deceased's death. This is to allow executors time to carry out their duties and responsibilities without any pressure from the beneficiaries. However, it should be noted that the executors are unable to unnecessarily or unreasonably delay the estate administration. By allowing the executors to have a year before they need to distribute the estate, this will allow for any claims that could arise from the estate to be dealt with. For example, if the estate was to have already been distributed prior to any claims being sought, especially within that first year, the estate may not have the capacity to deal with those claims or any potential costs being sought. So we have listed some of the steps the executor can take to protect an estate. So when an Inheritance Act claim comes, it must be brought within 6 months of the grant of probate. So it's therefore, if the executors have been put on notice of the claim, then they may choose to wait until after the 6-month period has passed until the estate is distributed. After the year has passed, if a beneficiary has concerns that the estate is not being processed or distributed, the beneficiary is then able to write to the executor and ask for further information. As mentioned, if this is before a year has passed since the date of death, then the executor is under no obligations to have distributed this prior to this. Catherine's now going to go through the next steps if there are any further issues.
So, in an ideal world, the executors would take all the steps set out by Elspeth to protect the estate. There'd be harmony between all parties involved. At the end of that executor's year, the estate would be distributed between the beneficiaries in accordance with the terms of the will, or in accordance with the rules of intestacy. The beneficiaries would be happy with the inheritance they received, but in reality, there are a number of issues which can arise. And this is not least because executors do not always appreciate or understand their responsibilities. So I've repeated the slide setting out those duties, and I'll now go on to discuss the problems which can and do occur in the administration of the estate. The role of an executor can be a demanding one and involve a significant amount of work. This depends on the complexity of the estate and any issues which can arise. It can involve a significant amount of work. There are legal, tax and administrative responsibilities, and it is important that an executor takes their role seriously. It seems fairly obvious, but executors cannot change a will. They might not like the contents or believe that assets would be more fairly distributed in a different way, or in line with the conversation that they once had with the deceased. But the reality is that they cannot make that decision to depart from the will. Now, this is important when considering the fact that executors can be sued by beneficiaries if they fail to comply with those duties and or cause losses to the estate. So, whilst executors are protected by the executor's indemnity, which means that they're entitled to an indemnity out of the relevant estate for costs properly and reasonably incurred in the due course of administration. However, this is conditional upon where such costs are properly incurred in all the circumstances. So it's important that they do properly administer the will in the terms of the will and in line with their duties. Now, there are several circumstances which can arise in the administration of an estate. And it can be a very stressful experience if conflict occurs. And it's not surprising, really, if you consider kind of the societal changes in life and family life as we know it. So getting married and having children was expected and seen as the norm. This is no longer the case. There's an increase in people not getting married. There's also an increase in blended families, second marriages, stepchildren. This all equates to a number of people who have an interest in the estate of a deceased. And as is frequently the case, there are conflicting opinions as to how the deceased estate should be administered. People are living longer and having relationships in later life, maybe due to a death of a previous spouse. So it's not difficult to predict that There may be issues arising where, for example, there's a second wife of the deceased. She's never got on with the children of the deceased from a previous marriage, but that she and one of the children or more of the children are named as executors in the will. This can cause conflict, and it is a common scenario where conflicts can arise. Another issue is that, my apologies about the slides today. Another issue is where children are staying at home for longer than they ever have done. Not uncommon for children in their late 20s or early 30s to still be living at home and remaining in the family home. That family property on death then becomes estate property. But if that adult child living in the property is also an executor, this can lead to difficulties in the administration of the estate, which I shall go on to discuss. So what are the types of disputes that can arise as a result of executors not carrying out their duties? The first of those would be disputes between the co-executors. It's important to remember that co-executors must act jointly to administer an estate. And it's very common for a deceased in their will to appoint family members as executors. This appears sensible. They had a close family relationship. They therefore seem best placed to carry out the deceased's wishes. But if the co-executors are siblings who've never got along, they're unlikely now to get along and agree with the decision that the other makes. Personal historical issues can get in the way of acting with neutrality, and there can be disagreements in relation to certain assets or properties, whether they should be sold or remain within the family. Another example is where one sibling has always lived closer to their parents. They were more involved with the care of the parents in later life and more involved in the day-to-day care for that parent. I mean, they may suggest they've got a better understanding of what their mother or father wanted. And we see this especially in cases if a will was made many years ago and some circumstances have changed. But unfortunately, those personal difficulties coming through, whilst they can lead to disagreements about how the estate should be distributed, if they're not resolved quickly, then they can quickly escalate into full-blown disputes where the executors just aren't getting on. Another example is where there's a professional executor which has been appointed alongside a lay executor or family member. I mean, this is usually where an executor can feel marginalised or pushed out of the decision making because of the fact that the professional executor is taking the lead. Now, I believe that the majority of disputes are between executors and beneficiaries, and there can also be a number of reasons for this. One of the main reasons we see is delay or inaction, where an executor has taken very little or no steps in relation to the administration of the estate. And this can be due to an executor not really understanding or appreciating their role or the steps that they have to take. But unfortunately, it is insufficient to do nothing. And this can obviously lead to tensions between executors and beneficiaries. And of course, beneficiaries who are expecting their inheritance are not simply going to stand by and not do anything if there are considerable delays. The next one is failure to follow the instructions on the will. I did mention this slightly earlier, but I wanted to also add that an executor cannot favour one beneficiary over the other. So as with the case of blended families, the beneficiaries could be the children of both marriages. But in this one particular instance, the executor is favouring his full siblings over any half siblings he may have. Well, this is in breach of his duties as an executor. There cannot be any bias and there cannot be favour to one beneficiary over the other. Another common issue which arises is a lack of communication with the beneficiaries. So, where an executor fails to provide the beneficiaries with regular updates on the progress of the administration of the estate. So, beneficiaries are entitled to estate accounts, which there is no specific document, but it's basically a list of the income, assets, expenses, and distributions. So, if this information has been requested by a beneficiary a number of times and simply been ignored, then this can cause friction. Another example is where beneficiaries receive substantially less than they expected, especially where it's a modest estate. And I mean, it's a valuation of assets usually that causes this problem. This could be the property, or there can be a suggestion that the executor has not declared all the assets and therefore the beneficiaries are receiving less than they should. An example of a dispute between a professional executor and beneficiaries, there can be issues if a beneficiary feels that their inheritance is being chipped away simply by the expenses that are being incurred by that professional executor. I believe as well, and we do see it, that disputes are more likely to arise where an executor is also a beneficiary. An executor, as I've said, has a duty to remain impartial. But where that executor is also a beneficiary, they've got an interest in the estate and in the amount of the inheritance they're due to receive. The two roles can be very hard to separate, and executors can get into difficulty when trying to balance those two roles. And you can see there where a conflict of interest arises. So, for example, common difficulties include where an executor is living in the family property. They've lived there. It's an adult child, as I've said. Adult children are now not moving out of the family home as soon as they used to due to financial issues. And so the executor is living in the estate property. They're not paying rent because they've never paid rent because they live with their parents. And now they don't want the house to be sold, but the will says the estate is to be distributed equally between all beneficiaries. And the only way to do that is to sell the property. And similarly, where an executor is also a beneficiary and does have the financial means to try and buy out the other beneficiaries' interests in the estate. Now, as an executor, they have a duty to obtain an accurate and fair valuation of the property. But as a beneficiary, they're going to want to obtain the lowest valuation in order to pay out the other beneficiaries' shares. Again, you can see where that conflict arises. So what can be done? And what's the best way for a co-executor or beneficiary who is concerned that an executor has breached their responsibilities or duties to try and resolve the issues? So the first thing I would say is do not immediately issue court proceedings. If there's anything you take away from today, it has to be that, because it's easy to overlook the effect of initial aggressive contact or correspondence with an executor. So I wouldn't recommend also jumping from writing an email to say, I've got a concern, for example, about the way you are, you've delayed the administration of the estate, to the next letter saying, we're going to remove you as an executor, we're going to seek our costs of doing so, and we're going to seek them directly from you and not the estate. Similarly, name calling, bringing up family issues from the past, they're not helpful in trying to resolve issues. And obviously, I appreciate that this is easier said than done. After all, there's been a death, usually a close family member. People are grieving and there are a lot of emotional issues for the parties to deal with. So the grieving process has to be considered, but there is still a need to try and work cohesively to resolve any issues between executors and beneficiaries or between co-executors. And you always have to remember that if the dispute really cannot be resolved and court proceedings would be issued, then any application being made to the court is going to need to be supported by evidence. So, for example, if the beneficiary is suggesting they've not been kept informed about the estate and they then make an application, they will need to provide evidence of their attempts to contact the executor, the information they requested, how often those attempts were made to contact, and what responses were received. So it's really not going to help matters if the only evidence which can be provided in support of that applications are, say, emails of a nature which somebody really wouldn't want to disclose because they're bringing up family issues and they're not getting to the point. So the first thing really does have to be, I've named this as cooperation, but is it possible to work together towards an outcome? Are you able to, is an executor or a beneficiary able to pick up the phone and try and speak to family members, or attempt to try and resolve the issues? I've said that that's difficult, and if not, the next best thing would be to seek early legal advice. And in seeking early legal advice, it's not with a view to issuing proceedings straight away, it's to try and narrow or reach an agreement as to the next stages. So that's going to involve initial correspondence, a letter of claim, confirming the position, and trying to engage and take the required steps of what the beneficiary or co-executor is saying that the executor has failed to do, and what can try and be agreed as to the next step forward. I mean, if you get to that point and both parties have confirmed their positions, then how is it possible to resolve the dispute? So the next stage is negotiation. So, for example, with a dispute between co-executors, it is possible if they've got, both co-executors have got to the point where they know that they've never got on, they're not going to get on, they can't agree in relation to how the estate should be administered and what steps should be taken, is to maybe take a step back for them and say, well, do we both agree to be removed, replaced by a third party? Now, this would generally be an independent professional executors. But I would say that even if that is agreed between the executors, there would still need to be an application to the court by consent for the approval of the removal of those executors and the third party to be appointed in their place. Now, I've mentioned renunciation as well, but I'm not going to go into this in any detail because we're dealing with issues that can arise after the grant has been issued, and renunciation or an executor standing down only applies where a grant has not been issued, or and also where an executor has not taken any steps in relation to the administration of the estate, or intermeddled in an estate as it's called. Now, I'd said previously that an executor cannot change the terms of the will, but the terms of the will can be amended as long as all the beneficiaries agree this between themselves. So the terms would be confirmed in what's called a deed of variation, which would need to be signed by all parties. That would then enable the executor to then administer the estate in accordance with that deed of variation. Now, this may be useful for circumstances where one of the beneficiaries is suggesting that they don't need their inheritance and that it should go to a different person, such as a sibling or a child or a grandchild. And I mean, if those circumstances don't apply, then the next steps to consider are alternative dispute resolution. So, I mean, all parties should consider alternative dispute resolution, and a court will expect the parties to have considered ADR prior to the issue of any court proceedings. Now, this can take a number of different ways of doing it. It can be informal negotiations, it can be offers, and it can also be where they go to an actual mediation, which is with an independent mediator. So, I mean, like I said, the court expects ADR to be attempted, and it can often lead to more timely and cost-effective solutions. But settlement isn't always possible. I mean, some parties are so far away apart in their expectations, or simply not willing to budge or move on their position, which means that they'll never reach an agreement. But nevertheless, the court will want to see that attempts have been made. Now, if all those steps have been taken and the next thing is litigation, like we said, this should always be seen as a last resort, not only due to the significant legal costs which can be incurred by all parties. Litigation is very expensive. Now, different ways of dealing with this. We're not suggesting that the first thing that should happen is that you should issue proceedings and hope that it goes to a full-blown trial where each party can give their opinion and say what steps that party has taken and what they should have done and why they haven't done it. So, I mean, in circumstances where a beneficiary has been provided with little or no information about an estate, or where they've got concerns about the value of an estate asset, then a useful way of dealing with this is to make an application pursuant to Rule 61 of the Non-Contentious Probate Rules. And this is for an inventory and an account by way of a summons. And this would be in front of a probate registrar, and an application is made, and again supported by a witness statement from the beneficiary. So again, this leads back to the things I was saying earlier about showing, you know, the steps. You have to be careful in the steps you take and the allegations made against an executor as to what they've done and what they've not done. A beneficiary has got to show that they have been reasonable in getting this information and hasn't really prevented the executor from doing this. Another way of dealing with an issue in relation to a specific area of dispute, or if the executors are kind of unsure as the best way to proceed because of the issues being raised by the beneficiaries, then they can make an application to the court for directions. And this is made under Part 64 of the Civil Procedure Rules. It involves a Part 8 claim form and a witness statement, and again supported by evidence of the letters between the parties and the attempts made to resolve their disputes. And as I've said, this can be regarded as an executor taking proactive steps to resolve any issue or dispute. And most importantly, it can be seen to be in the best interest of the estate. And this is important when considering costs, because it can be seen as less risky to an executor to take these proactive steps rather than do nothing or simply just ignore any correspondence. Another way of doing another application is to remove and substitute the executors, which is done under Section 50 of the Administration of Justice Act 1985. Now, if we were dealing with things where it's pre-grant, there's a similar provision in Section 116 of the Senior Courts Act 1981. But you have to remember that the beneficiaries don't have any right to demand that an executor steps down. And in the absence of significant wrongdoing on the part of the executors, it is difficult to actually get this. The court does have a broad discretion, and it is really one of those, unless you can prove that there's been some kind of fraud or wrongdoing on the part of the executor, somebody needs to think carefully about taking any further steps. Now, I am aware that my colleague Stephen Lawson has done a previous contentious clinic in relation to the exact steps and processes in relation to removing executors under that section, and I would definitely suggest watching that if you haven't done so already. So, I mean, the overriding principle is that the court will expect the parties to have taken lots of steps before getting to court proceedings and before making these applications or even commencing litigation. So in respect of that, I'm now going to pass back to Elspeth, who is going to talk through the pre-action protocol and the ACTAPS code.
Thanks, Catherine. Yeah, as a finisher, we just thought we would discuss the pre-action protocols and the ACTAPS codes as a bit of a refresher if a claim was brought against an estate. So the pre-action protocols explain the conduct and steps the court would normally expect parties to take before issuing proceedings. There isn't a specific protocol which applies to the contentious probate claims. Instead, the relevant steps are set out in the practice direction, pre-action conduct and protocols. We have listed the objectives there on the screen, but in essence, the parties should set out their position, understand how best to proceed, and try to settle the issues without proceedings. This is to achieve the objection of reducing costs of resolving the disputes. Prior to proceedings being issued, the steps include the claimant writing to the defendant, setting out concise details of their claim. The letter should include the basis on which claim is being made, a summary of the facts, and what the claimant would like from the defendant. It is important to disclose any key documents or evidence at that stage and to sort of fully set out their position. This will allow the other side to fully understand your claim in detail. The defendant should respond within a reasonable time, and this is noted to be 14 days in a straightforward case, but no more than 3 months in a very complex one. The response should include confirmation as to whether the claim is accepted, and if it's not, the reasons why, together with explanations to the facts and parts of the claim which are going to be disputed. As Catherine mentioned, litigation should be a last resort. We did just want to highlight the possible sanctions which can be imposed by a court for non-compliance with the pre-action protocols and if you don't engage with any settlement or ADR steps. This could be that an order that the party at fault pays part or all the costs of the other party, whether this be on a standard basis or on an indemnity basis. There can also be awarded or deprived a party of the interest for the specific period at a higher or lower rate than would have otherwise been awarded, depending on the party at fault. Finally, we just wanted to have a brief overview of the ACTAPS Code. This was formed in general terms to cover the broad range of probate and trust disputes. It was designed as a means of developing best practice in areas or situations which was not covered by the practice direction by amplifying the basis principles and considering methods of carrying the objectives into effect. The main two aims are to encourage the resolution of disputes without hostile litigation, and even when litigation may be necessary, to ensure that it is simplified as far as possible. And that is just a brief overview of the practice directions and the ACTAPS Code. So I'm just going to hand over back to Lindsay, who I think will discuss the RDN process.
Hi there. Thank you, Catherine. Thank you, Elspeth. That was really informative. Just wanted to comment on the fact that all sessions will be available are available on the IDRN, and this session will be available this afternoon on the IDRN. I popped in a link to the IDRN in the chat, so please do register if you're not registered already. It's completely free. Not only does it host all of our CPD and contentious probate sessions and any other resources that we have on contentious and non-contentious situations, but we've also, in November, we brought out IDR Intel. What we felt was missing from the IDRN was sort of a more up-to-date commentary on the sector itself, and that has actually been added in November, and we have been updating that monthly since then. We also add in any ad hoc news along the way. IDR Intel is edited by Stephen Lawson, who is one of our partners at IDR Law, and is also the chair of the Law Society Wills and Equity Committee. So obviously, as is ear to the ground, so lots of information on regulatory changes and commentary and all sorts. So please do register and make sure you share with your colleagues. We also have lots of legal tech tools on there for free that you can access, and they aid in navigation and prevention of claims. So the link's there. We've also added in, I've also added in Christian's email address for CPD certificates. Should you wish to get one of those following the session, please do email Christian. The next session will take a step away from our Deaf to Distribution series, and Stephen Lawson, partner, and Catherine Ayres, solicitor, will be bringing you a session on wills and blended families. So yeah, please do join. And if you do register for the IDRN, you'll get updates on the next session and how to register. Thanks again for joining. Any questions, please direct them to Catherine or Elspeth for legal stuff, and anything to do with the IDRN, please contact myself. Thanks again. See you next time.